Good morning and good afternoon to everyone. While we wait a minute for everyone to log in, I thought maybe if you are interested in typing in possibly the location you're signing in from or your pet's name, if you want to share that with us, just as we wait a minute for everyone to get signed in and I can begin introductions. But if you'd be willing to do that, that could be fun just to share that. We're always interested in knowing where you're at and your pet's name would be great. And hopefully everyone is having a good day and good weather wherever you are. Okay, and I think that I am going to get started with introductions. So welcome to Gray Muzzle's webinar on planned giving. My name is Jim Pakula, and I'm the treasurer of the Gray Muzzle organization. And I would like to thank everyone for joining us today. For those of you who may not be familiar with Gray Muzzle, we are the largest national nonprofit organization focused specifically on senior dog well-being. We are pleased to have Peggy Hoyt as our presenter today. Peggy is an attorney practicing in family wealth and legacy counseling, including trust and estate planning and administration, elder law, and animal law. She is a founding partner at Hoyt and Bryant LLC and is dual certified by the Florida Board in Wills, Trust and Estates, and Elder Care. Peggy is the author of All My Children Were Fur Coats, How to Leave a Legacy to Your Pet, an informative guide for pet owners who want to include their pets in their estate planning, and her Amazon bestseller, 101 Ways to Flub Up Your Estate. She also speaks at local, regional, and national levels on estate planning and elder law, including, among other topics, pet planning. Peggy has been featured on CNN Financial News, the Wall Street Journal, and the Orlando Sentinel for her dedication to pet planning. And to this end, she hosts a weekly podcast entitled All My Children Were Fur Coats. She also founded Animal Care Trust USA, an organization dedicated to keeping loved pets in loving homes. Peggy, welcome, and thank you for being so gracious with your time today.
Thank you so much. It is my pleasure to be here and to share with everybody today this really important topic, actually, about doing well by doing good and leaving a legacy. So we're going to talk a little bit today about charitable giving in the 21st century. And as part of that presentation, here's just my bio information that is summarized. My contact information is also available. And I just want to give you a brief background on charitable giving today. So there are more than 1 million charitable organizations in the United States, and about 30,000 new ones are created every year. And as I was looking for some statistics to share, I thought it was interesting that there's an organization out there called YouGov, and they discovered that 69% of Americans will donate to a charity during their lifetime. And half of the young people under 30 say they have already donated, while 85% of Americans who are 65 years of age or older have donated. Another really interesting fact is that Fortune and Forbes magazines have estimated that the baby boomer generation, that's those of us born from 1946 to 1964, will leave approximately somewhere between 68 and 73 trillion dollars to their children, making that generation the richest generation in American history. Yet the baby boomers still continue to be one of the most generous generations. This is according to a Blackbaud study on generational giving, and it is estimated that about $11.9 trillion will be given to charities, both during a baby boomer's lifetime and as part of a proactive legacy plan. And that's really what we're going to talk about today, is creating a proactive plan that may include charitable giving as part of that plan. So Ben Franklin, why plan? He said that failure to plan is like planning to fail. And we probably all heard that before, but in my world of estate planning, less than 50% of Americans have done any estate planning. So I think that hope is not a plan. So in talking about some estate planning essentials, if you don't have a plan, then your state has a plan for you, and it probably isn't the plan that you would have chosen. So my partner Randy and I, we are we very commonly say that wishful thinking isn't planning. Telling someone what you want isn't planning, and only planning is planning. And I like to say that Americans are very, very optimistic because we say, if I die and when I win the lottery. And I hope each and every one of you has the opportunity to win the lottery, but we know that that probably isn't true. But I also do believe that Ben Franklin was wrong about one thing. It's not just about death and taxes. It's about the only thing in life that's certain, and that is change. And because we're living in a world of constant change, it's hard to stay abreast of all of those changes and the things that are happening on all the different sectors, but especially in the world of estate planning. Anytime we fly, the airlines remind us, put on your mask first so that you can help others. And we feel the same way in our practice about creating a personal estate plan. Even though you're creating it for you, you're creating it also for the benefit of your spouse and the people that you love. And there are two aspects to planning. The first is what happens while you are disabled. And I call this alive but not well. And it is often an overlooked area of planning. But the things that are important in that alive but not well phase are durable powers of attorney for financial matters. And in my plans, I like to include pet provisions because I want to make sure that whoever I've nominated as my financial agent also has the ability to help make some decisions about my pets during my lifetime. I also recommend durable powers of attorney for healthcare decision-making. These authorize people that you trust to make healthcare decisions for you when you're unable to make your own healthcare decisions. Next would be a living will. A living will is not a living trust, so sometimes they get confused, but a living will is your end of life declaration. It says how you want to be cared for at the end of your lifetime. Do you want to be on a respirator or not? Do you want artificial food or hydration or not? Some people get confused that a living will is a DNR, also known as a do not resuscitate, but they are not the same thing. Typically, you can only get a DNR from your doctor, not from your lawyer. In addition, you might come across an instrument called a pre-need guardian declaration. This is a document that if all else fails and you find yourself in the guardianship court, that at that time, we would file this document letting the court know who you would choose as the person to make your financial decisions and your healthcare decisions. As we move out of the disability phase and we move into the death phase, so then the not alive phase, the documents that become relevant there are your last will and testament, a living trust with a pour over will, and this is where our legacy strategies can come into play, charitable trusts or other planning strategies that we might implement as part of our plan. I do want to set aside a couple of myths, though, about trusts before we really get into this. And one of the myths is that trusts are only for rich people. And that definitely is not true. Trusts are for people who have people or pets or individuals that they need to plan for, and a trust is the best way to do that. Because we can create the instructions for a trust that set out exactly how we want our money to be used for the people or pets that we care about. In addition, there's a belief that trusts save on income taxes. That's not true. Trusts are typically flow through entities. So the income that's earned on the assets in your revocable trust are actually taxed on your personal income tax return. Another myth is that trusts provide asset protection during lifetime. If you put assets into a revocable living trust and you have access to those assets, so do your creditors. So that's a myth that I want to bust right now, is that living trusts provide no asset protection during lifetime. There's also a myth that trusts are expensive to create and maintain. I will say quite honestly that there is a cost to create them and there may be a cost to maintain them, but I don't know whether expensive would be the best word to use for that, because I think it's all relative to what you're trying to accomplish. So I think you have to do a cost benefit analysis as to whether or not trusts are affordable for your situation. There's also a belief that trusts require a loss of control. And again, that's just not true, because if you create a trust during your lifetime for your benefit, you can absolutely be the trustee and remain in control. There are planning techniques using irrevocable trusts for the purpose of removing assets from your estate for estate planning purposes. And in those cases, you may have to have an alternate trustee, someone that is not you, so that you can have those assets removed from your estate. And then one of the features about trusts that people like is that trusts avoid probate, and that's true. But what's not true is that trusts, just by creating a trust doesn't mean you're going to avoid probate. You have to actually put assets into that trust by retitling them in the name of the trust, or transferring real property to the name of the trust, or naming your trust as the beneficiary of assets. So trusts don't always avoid probate because they don't always control all of the assets that are part of your estate. So some of the ways that trusts can protect your family is that you can create a trust for the benefit of a surviving spouse that would provide them with asset protection in the event of a remarriage, or in the event there are changed circumstances in the future. Trusts are often used in blended family situations where you might be in a second or third or more marriage and have children from multiple family arrangements. Trust can also help protect us from catastrophic creditors if we were in a car accident or had some other type of catastrophic financial event. So even though we can't protect ourselves, we can create trust for the benefit of protecting others. We can also use trust to provide protection for our surviving spouse in the event that they need to go into a nursing home and have access to government benefits for their eligibility. We may also want to be protecting an unmarried partner, so a life partner if you're in an unmarried relationship. The unfortunate thing about life partners usually is that under most state laws, our life partners are no more than legal strangers to us. So we have to create legal directives in order to confer benefits to our partners that we're not married to. This would include financial decisions, healthcare decisions. We need to be sure that our asset ownership and our beneficiary designations are consistent with our estate plan. And by using trusts, we can provide our life partners with asset protection as well. A number of years ago, I wrote a book on unmarried partners called Loving Without a License. And in the process of writing that book, I was an unmarried person at that time. I'd been in a long-term relationship. And because of that book, I actually got married. There are 1,100 rights that you gain from being a married person. For protection for our children and our grandchildren, they may need protection from themselves because of their age or their immaturity. We may also want to protect kids from financial inexperience, and this is a disease that I call affluenza. We may need to protect our children in the event of drug or alcohol gambling, or other dependency disorders. We can create trusts for the benefit of our children to provide them protection in the event of a divorce or a catastrophic creditor event in their lifetime. So what I see in my practice is that many times people will choose trust planning because of the people or the pets that they want to protect. So our pets are our children who wear fur coats, and pet trusts are now valid in all 50 states and the District of Columbia. So it does mean that we can create a trust for the benefit of a pet for the pet's lifetime, and that it would be considered a valid trust. In my case, I have 6 dogs and 2 cats and 4 horses. So I've created a pet trust where at my death, all of my assets will go into a trust for their benefit. They will remain in my home, and I will have a full-time pet caregiver that will come live in my home, take care of my pets. And at the end of the last of my pets to pass away, then I will be benefiting charitable organizations that are important to me. That's to just give you an example of one way that you could plan for pets. In addition to using pet trusts, I also have a veterinary power of attorney, which I give to my pet caregivers so that they can make decisions about my pets in my absence if there was a catastrophic health event. I always encourage my clients to fill out what I call a loved pet profile. These act like babysitter instructions, but they provide the instructions related to your pets to be given to your pet caregivers that are going to give them everything they need to know. So it's kind of like if you were leaving a child with a babysitter for the first time, you want to make sure that you leave as many instructions as you possibly can so that they will know everything they need to know about your pet. And I suggest that people do these for both short-term pet caregivers as well as long-term pet caregivers. Other planning we need to do for our pets includes disaster planning. So what would we do in the event of an emergency? Where would we go? What kind of things would we take with us for the benefit of our pets, including crates or food or their veterinary records? I also recommend to folks that you carry in your wallet an emergency alert card that lets people know that you have pets that are home alone, so that first responders or others will be aware that there may be pets at your home that need to be cared for. And then also you can put decals on your home to let first responders know the location of pets in your home, how many pets are in your home. And you can also put that same information on a decal that you could stick on the dashboard of your car. I recently put some stickers on my house just saying dogs inside so that people know the location of the dogs within the house, so that they don't get surprised if they walk into that room, but also that they're aware that there are pets that may need care. And then you have to have a written plan. Like anything else, you can't just leave it to chance. It's important to have all of the instructions for your pets in a well-crafted and frequently reviewed written plan. I've created notebooks for all of my various pets. So I have one for my horses, and then I have another one for my cats and my dogs that have all of the information that's relevant to their life. Because not everybody's going to create a trust for the benefit of their pets, I created a national organization called Animal Care Trust that actually provides some pet trust options for people. One of those options is what's called a community pet trust, and it's a trust that you can join rather than creating your own pet trust. There are testamentary, or what I call standby pet trusts. These are trusts that are created as part of your larger estate plan. And then there are standalone pet trusts. These are pet trusts that are personalized or custom drafted by your attorney for your benefit and your particular needs. I do recommend seeking professional guidance in this arena. I don't think do-it-yourself is recommended, only because there's way too much at stake, meaning the lifetime care and safety of your pets. So, you know, you can tell, I'm sure that this is a favorite topic of mine, and that one I could talk on for an extremely long period of time, but that's not our primary focus today, even though I know all of us here today are pet lovers. So if you want more information, you can visit my website at actforpets.org and look at all of the various options that are available to provide for your pets. All right, we want to talk about other ways that we can create lasting legacies. One thing that is often overlooked is family stories and traditions. What are we doing to pass on our family stories and the traditions of our family? Also, heirlooms and collectibles. So sometimes we have to leave instructions regarding our heirlooms and collectibles because people just don't know what their value is if they don't know the story behind the item. And more, it seems that younger generations are not interested in all of our stuff, the stuff that we buy bigger houses for. And so we really have to be mindful of how those assets are being handled as part of our estate. And then, of course, our primary purpose for being here today is to talk about charitable giving, both during lifetime and at the time of our death. So when is a good time to create a plan or to update your plan? Well, anytime you have a change in your personal circumstances. I call these the 4 L's. So the first one would be a change in your life. The birth of a child or a grandchild, the loss of a loved one, a new pet in your life, or a change in your personal health circumstances. The second L is a change in the law. Changes in the law occur frequently, and sometimes these changes mean that we need to create an estate plan, and other times they mean that we need to update our existing estate plan. Sometimes changes in your lawyer's experience. That's the third L, your lawyer's experience. And believe it or not, we get smarter as time goes on. So I always tell folks that 30 years ago, when I started practicing law, I did the very best job I could do for you at that time, but I can do an even better job today. And then the fourth L is changes in your legacy, how you want to leave assets and who you want to leave them to. And there's lots of techniques for that, and we're going to get into that right now. So why create a legacy plan? Number one, as a commitment to your passion. Number two, you may have a desire to live up to values that were instilled in you by your parents and your grandparents. You may want to just give back. You might want to make a difference. You might want to be a part of something larger than yourself. You might want to be recognized as a philanthropist. You may want to feel united with others of similar commitment and values. You may want to commemorate a loved one, so making a gift in honor of someone you love. You may want to share good fortune. And you may want to support an organization and its mission because you value what it offers to both you and to your community. So there's lots of excellent reasons to create a legacy-based plan. I have a little joke here that I just wanted to include. So, of course, organizations are always seeking donors, and this says, after 18 years of cultivating Patrick Daniels III, may I present his planned gift to us. And in this case, they left the dog Twinkles. All right, so what are the different ways that we can create a legacy? Of course, you can give it now. You can give cash, you can give tangible personal property, you can make outright gifts of appreciated assets. This could include stock or real estate. You can make gifts from your IRA. I'm going to talk about that a little bit more. So give it now or give it later. So you might make a bequest in your will or your trust. You might name a charity as the beneficiary of your retirement plan or your life insurance. And then there are some planning strategies where you can give the asset now and keep the income from that asset. So there are what are called split interest gifts, and these might include charitable gift annuities, charitable remainder trusts, or other types of charitable giving. And then a last technique here would be to give the income now, but keep the asset. There's a charitable lead trust that's also a planning tool where the charity gets a stream of income for a period of time, and then you get the asset back, or your loved ones get the asset back in the future. Oops, sorry. So some of the benefits of giving are reduced income taxes, because when you make a gift, you can deduct that gift on your income taxes if you are a itemizer. If you have an asset that has appreciated in value, you can either reduce or eliminate that capital gains tax entirely. I mentioned you could get income back from a gift, so that would be another benefit if you want to create a stream of income for yourself by giving the asset, but keep on enjoying it. And you can definitely reduce your exposure to estate tax. So very simple to create a zero estate tax plan using the benefits of charitable giving. And that's one of the conversations I have with a lot of my clients is their eagerness to leave charitable gifts and how that can benefit their estate if they have a taxable estate. And then I just have a little reminder here to always consult with your legal and financial and tax professionals in this regard. All right, so charitable giving isn't the ultimate test of one's humanity, but it does give them some numbers to play with. So when we're approaching the pearly gates, we want to make sure that we've done the best we can do with our charitable giving. All right, let's talk about some of the tools for giving. Some of these I've already touched on a little bit, but an appreciated asset donation. So let's say, for example, that I bought Coca-Cola stock when it was $10 a share. It's now appreciated to $100 a share. So there's a $90 built-in capital gain there. And if I give the appreciated asset to a charity, let them sell the Coca-Cola stock and keep the proceeds, then I avoid that capital gain. I don't have to pay the tax on the capital gain, and I get to take an income tax deduction for my donation. Qualified charitable distributions from retirement plans. I'm going to talk more about those. Donor advised funds, charitable remainder trusts, charitable lead trusts, and then family foundations I'm going to end up with. And you can see all of these have little acronyms that go with them. And in the estate planning world, we call them the alphabet soup of estate planning. So we have CRATs and CLUTs and all kinds of different acronyms. So I mentioned the gift of appreciated securities. These are securities that have a very low initial cost basis. It could be securities that are held in a non-retirement account. If you sold them outright, the highest capital gains tax rate would be 20%. So in this instance, you can avoid the capital gain and receive the income tax deduction. This works with all gifts of appreciated securities or assets. It doesn't have to be stock. It could be property, or it could be other collectibles. The qualified charitable distribution is a very popular tool these days. It's known as a QCD, and it is available to donors over age 70 and a half, and they can make a charitable gift directly from their retirement account. So things like your IRA or your 401k, especially if you don't need this distribution for your lifestyle and it would just create a tax burden for you. Normally, withdrawals from your IRA or your 401k would be taxed as ordinary income. And by using the qualified charitable distribution, you can make a gift up to $100,000, which would be part of your required minimum distribution, to be distributed directly from that qualified account, the IRA or the 401k, and sent directly to the charity. So you don't take it as income yourself and then give it to the charity. It goes directly to the charity. In this case, you don't have to pay the income tax, but correspondingly, you also do not get a offsetting deduction. You just get to avoid the income tax on that required distribution. Oops. And starting in 2023, you can now use this charitable distribution to make a one-time $50,000 gift to a charitable remainder trust or to a charitable gift annuity. Donor advised funds are like little mini family foundations. So they're designed for flexible giving. You can open an account with a donor advised fund sponsor. It might be a foundation that is sponsored by a brokerage firm like Fidelity or one of the other brokerage firms. There are community foundations, perhaps in your community, that also offer donor advised funds. You make an irrevocable gift of appreciated assets or cash to the donor advised fund. And then you receive an immediate tax deduction for that contribution. It can be up to as high as 60% of your adjusted gross income for cash donations, 30% for stock donations, and you can have a 5-year carry forward for unused deductions if your deductions exceed the amount that you need for that particular year. And the assets can then be invested, professionally managed, creating tax-free growth inside the donor advised fund. And then you can elect to make distributions to your favorite charitable organizations at any time. So you can make the gift in 1 year to the donor advised fund, but not make the distribution to the charitable organization until another year. Although I just got a friendly reminder from my donor advised fund that I hadn't made a distribution in a period of time, and they were encouraging me to do so to keep that account active and also to benefit charities. Actually, I have 2 donor advised funds, and so I had ignored one and I was primarily using the other. And this is just a little illustration of how that might work. So the donor makes a contribution of cash or appreciated securities to a donor advised fund. It's professionally managed, and then you can give to as many charities as you like. And in the process, you can avoid capital gains and receive an income tax deduction. There are income producing legacy gifts, those that can provide a stream of income for you as the donor. One is called a charitable gift annuity. Typically, these are offered by charitable organizations. So if I were to make a gift to an organization that had a charitable gift annuity program, they would hold that money for me. They would make a stream of income payment to me over my lifetime. And then at the time of my death, they being the charity, would retain the remainder benefit. And these can be immediate, so you can either start taking income immediately, they can be deferred, or in some cases, they can be flexible. Charitable remainder annuity trusts and unitrusts are charitable trusts where you make a contribution to the charitable remainder trust, and it pays you or your spouse or other loved ones a stream of income for their lifetime. And then at the end of that person's lifetime, the charity or charities will get the remainder benefit. So it's more of, it's similar to a charitable gift annuity, but it's one that you manage or someone else in your family manages. One instance that I can give actually, which actually worked out very well for the client. She had worked 40 years for Walgreens organization and had accumulated a lot of corporate stock that was paying a pretty low dividend. But now she was retiring, and so she contributed all of this highly appreciated Walgreens stock to a charitable remainder trust and took back a stream of income that was 6% annually, so much higher than she would have gotten had she just retained the stock. She got the tax deduction, she'll get the charitable deduction, and at the end of her lifetime, it will go to her favorite charities. So you can see this doesn't work for everybody, but it does work for people who are charitably minded and would appreciate the stream of income rather than the use of the principal. So the immediate benefits are going to be income tax deduction. Again, you can avoid the capital gains tax on transfers. You can take income for your lifetime or for a period of years. It does remove the asset from your estate for estate tax purposes. And there are several different types of charitable remainder trusts, probably more types than most of us are aware of. The charitable lead trust, as I mentioned, is kind of the opposite of a charitable remainder trust. So a charitable remainder trust, you as the donor get the stream of income, and then the charity gets the remainder. In a charitable lead trust, the charity gets the stream of income for a period of time, and then the individual or their family gets the asset back at some point in the future. So you can create these during lifetime or at death. Most commonly, I see them created at death. And when we do that at death, we call them testamentary charitable lead trusts, or TCLATs. And so you can take an estate of any size, but if it exceeds the estate tax exemption amount, typically the way a testamentary charitable lead trust would work is that it would take the amount over the taxable exemption, put it into the TCLAT, pay the charity a stream of income for a sufficiently long period of time to zero out the estate tax, and the remainder would come back to, typically it would be your heirs, because now if you're doing it at death, you as the donor would be deceased. I have lots of individuals who use this as a planning technique under very particular circumstances, but they work really well. Family foundations. These are for families that really want to create their own charitable family foundation so that they can manage the assets and then create charitable programs or make gifts to existing charitable organizations. They have significant income tax benefits, capital gains tax savings. They can eliminate estate tax exposure while retaining control of the assets in the family. So that's why they're called family foundations, because typically the board would be made up of you and extended family members. You can support multiple charitable causes. You can instill values and traditions in your future generations, helping them to deepen their social consciousness and develop real world skills. So you've probably heard of the Bill Gates Foundation. That would probably be the most famous family foundation that's out there. But many, many, many families create these for the benefit of future generations. Just another really cute little cartoon here. So I wanted to give you a list of some resources here at the end if you want to read more about planning for your pets, or even charitable giving, because I have a whole section in my book on charitable giving and where that fits in with planning for your pets. Because I always suggest that if you're planning for your pets, the remainder beneficiary should be your favorite charity. I don't like naming people as remainder beneficiaries to charitable trusts because I don't want the people to be incentivized to try to bust the trust and put the animals at risk. So I prefer to have the assets available for the pets during their lifetime, and then to charity when the pet trust purpose is complete. All right, I'm going to turn the floor back over to Jim for questions. I see that we have some in the chat.
Great. Thanks, Peggy. That I appreciate all the information. Very informative. I'm sure there's many questions that Amanda will go through with you. If I can start real briefly too, is I was really liked what you had talked about setting up the trust for your pets to make sure they're taken care of, and especially to be in your home, in their home, say after your passing. Is there anything that, or quickly, that maybe the attributes or what's taken into consideration for who to choose to be the administrator of that? Because I know I've seen just on the accounting side issues with people and who's administering trust. Is there anything that you can tell us quickly what you should look for to make sure you have the proper administrator of that trust?
Yes, you probably want a professional administrator if you can have one. Some people want to choose their pet caregiver as the administrator as well. I don't always recommend that because then they're really on both sides of the equation. They're caring for the pets and they're managing the money. The difficulty is really finding professional organizations that would be willing to manage a pet trust. And one of the reasons that I have discovered that large banking institutions typically are not interested in this is that usually when we're creating a pet trust, it may not have sufficient assets in it to meet the minimums of larger organizations, which typically have somewhere in the $1 million to $3 million range as a minimum for their trust management services. You can certainly ask attorneys and CPAs to be pet trust administrators, but that was also one of the reasons why I created Animal Care Trust USA, was so that they could be in a position to act as a trustee on behalf of pet trusts when asked by individuals to do so. So that was a great question, because the management of the assets is not as important as the care of the pets, but it is very important to make sure that the assets remain intact for the benefit of the pets.
Perfect. Yeah, thank you. Amanda, can you share any questions that we might have from our guests?
Sure. We have a question from Allison. I am here on behalf of a nonprofit charity that receives inquiries from individuals wanting to leave us in their will and estate. They want to put stipulations in their will that state they want us to take their pets in order for us to receive the allocated money for our charity. What should we be requesting as people are creating their wills to approve or decline the stipulations they are setting? And what do these individuals need from us as approval for their requirements?
All right, so this is a very specific question to your organization, but it's a good one, Allison, because there are more and more pet-centered organizations that are getting asked to take people's pets in exchange for a charitable donation. If you are going to do that, I would recommend that you create a program for that purpose, so that you do have review requirements, so that you do have minimum funding requirements. We don't want people to leave us a horse for its lifetime care and then leave $1,000 for the lifetime care of that horse. We want to make sure that, you know, there are sufficient resources available to take care of the animal for its lifetime. So specific program would be the absolute right way to go with that.
And Terry asks, what is the best way to find an attorney who's very well versed in the pet trust arena?
That is a very good question, because although I am trying to build a national network of pet-centered attorneys, it's a long road. And I would suggest, though, that there are organizations like Wealth Council, which is a national organization of estate planning attorneys, that they do have a focus on training people to create trusts for the benefit of pets. But I think word of mouth is going to be your best bet, asking people that you know if they know an attorney that works in the area of pet trust planning. You can, of course, reach out to me for pet trust planning. recommendations. And if I know of somebody, I'm more than happy to recommend them to you. And if not, maybe we will work together.
Another question, if you create a pet trust and the person designated to care for the pet cannot end up taking care of this pet, what happens to the pet trust?
So all of those answers should be addressed in the pet trust itself. So I like to always name 3 people or organizations as designated caregivers for pets, so that we don't end up in a situation where our pet ends up in a shelter. That's the whole purpose of creating a pet trust, is so that that doesn't happen. But if the people we've selected are unable or unwilling to take care of our pets, hopefully we have a provision in the pet trust for the trustee to nominate a different pet caregiver or an organization that could provide that pet with lifetime care. And then when the pet trust is terminated, as I mentioned earlier, it would typically go to your favorite pet charities.
I believe that's all the questions I'm seeing right now. Kelly said, incredibly valuable information. Thank you so much.
You are so welcome, and my contact information is here. I believe you will be sent a follow-up email with more information. And so if you have an individual question, you are more than welcome to email me for that purpose.
Peggy, we also had a request for your slideshow, if you would be willing to share that, and if I could send it out in the follow-up email, because our viewers thought it had very, very important information that they want to keep.
Okay, sure. I'll send you a PDF version and you can share that.
Awesome, that would be great.
Can I have one point before we go? Just it's not really a question. It was just a comment that regarding the pet trust, but I think again is a great idea. Yesterday I had the opportunity to visit one of the grant winners from Gray Muzzle, the shelter up here in Palatine, Illinois, and they had just brought in a 8-year-old dog named Panda, whose owner had passed away, and Panda ended up coming up here to the shelter to be adopted. And it was just the sweetest, well-behaved, well-trained dog that, again, is just at that point looking for a loving home, and hopefully that can happen. But to your point, Peggy, too, if there was, if they had the ability, or it's possible to have the care taken, filling out the trust, how your pet should be taken care of after your passing, it would be so much better too if you have the ability to do that, to see that firsthand of just these sweet animals coming in that looking for a home also after being in a great home for so long. So it's really important, and it's something to think about. And it's great that basically on the legal side, there's the ability for pet owners to make sure that they're planning for the care of their pets also.
No excuses.
Right. All right. I think unless there's anything else, I think we're all set. Peggy, thank you very much for a very informative session. It was very enlightening in a lot of aspects. Some bit close to my heart, being an accountant, talking about some of the deductions and the advantages of being able to contribute to some of these charitable trusts, I think is really important. So hopefully our attendees learned a lot. Thank you for joining us. We look forward to you being a part of our next webinar series. And I believe it is time to say goodbye.
Thank you so much. I appreciate everyone. Take good care of your pets.
Bye, everybody.